Greetings, YouTube. Judge Vaughn Walker has overturned Proposition 8 in California. He finds that, and I'm quoting, Proposition 8 fails to advocate any rational basis in singling out gays and lesbians for denial of marriage license. In addition, he finds 13 relative facts in this case, and these facts will be used in appeal cases and will be used all the way up to the Supreme Court if it ever goes that far, and I wouldn't be surprised if it did. These facts are: marriage is and has been a civil matter subject to religious intervention only when requested by the interveners. California, like every other state, doesn't require that couples wanting to marry be able to procreate. Marriage as an institution has changed over time. Women are given equal status. Interracial marriage was formally legalized. No-fault divorce made it easier to dissolve marriages. California has eliminated marital obligation based on gender. Same-sex love and intimacy are well documented in human history. Sexual orientation is a fundamental characteristic of a human being. Prop 8 proponents assert that sexual orientation cannot be defined as contrary to the weight of the evidence. There is no evidence that sexual orientation is chosen, nor that it can be changed. California has no interest in reducing the number of gays and lesbians in its population. Same-sex couples are identical to opposite-sex couples in the characteristics relevant to the ability to form a successful marital union. Marrying a person of the opposite sex is an unrealistic option for gay and lesbian individuals. Domestic partnership lack the social meaning associated with marriage, and marriage is widely regarded as the definitive expression of love and commitment in the United States. The availability of domestic partnership does not provide gays and lesbians with a status equivalent to marriage because the cultural meaning of marriage and its associated benefits are intentionally withheld from same-sex couples in domestic partnerships. And lastly, permitting same-sex couples to marry will not number of opposite-sex couples who marry, divorce, cohabitate, have children outside of marriage, or otherwise affect the stability of opposite-sex marriages. All of these relevant facts are now part of the court record. As I said, they will be used in future cases, and this is important because by stating these as flat-out facts, the judge has laid a foundation that's going to make it very difficult for opponents of same-sex marriage to overturn it elsewhere. I'm hoping that eventually California at least will realize they can't oppose this, and eventually this will go all the way to the Supreme Court and be overturned on a national level, just like it was with interracial relationships in 1967 in the Loving versus Virginia case. And I still say that anyone who's read the outcome of the Loving versus Virginia case has to be intentionally blind if they don't see how it is relevant to same-sex couples. Love is love, folks. Who you marry has nothing to do with your gender, your sex, or your orientation. It simply has to do with who you love. And if anyone wants to oppose these marriages, they are the ones with the agenda. Because the people that want to get married just because they love somebody. And I don't see any reason that should be opposed. We're talking about consenting adults here, folks. What consenting adults do between each other is no one else's business. And where love is concerned, I'm always going to err on the side of love.